to today's episode of Party Like a Marketer, the podcast focused on cannabis marketing, public relations, and authentic storytelling. I'm your host, Lisa Buffo. And members, thank you so much for all of your support this year. We have had an amazing 2023 and are so excited about our 2024 lineup. And I want you to remember that we have our last two State of Cannabis Marketing webinars on December 5th and December 14th, talking about what happened in 2023 and where we see things going in 2024, with a specific focus on legal considerations as well as the new ROI. And on Tuesday, December 5th, we've got our Meet the Cannabis Press webinar with MG Magazine, Benzinga, Forbes, Cannabis and Tech Today, Marijuana Venture, and Cannabis Business Times. Lastly, if you're not a CMA member already and you want to join, now is the time. We are running a special for through the end of the year for annual business members. So you get access for up to 7 people on your team to all of our member benefits, which you can find on our website. And we're adding value through the end of the year. So that includes 2 hours of complimentary strategy consulting on your 2024 plans or whatever projects you may have. It includes a media feature on our blog, newsletter, and social media, as well as 10 hours of exclusive content from our Future of Cannabis Marketing TED-style talks. Now, today's guest is Mary Shapiro, the founder and managing director of Evoke Law, based in Bay Area, California. She's an intellectual property attorney specializing in trademark, consumer protection, copyright, and internet law. And the firm's focus is serving the cannabis industry. For 20 years prior to her legal career, Mary served in a variety of marketing positions in the book industry, including roles in retail, distribution, and publishing. Mary started her legal career in 1999, and her cannabis practice began in earnest in 2009, offering specialized legal services in intellectual property and consumer protection. Mary strives to assist cannabis operators in selecting strong and enforceable brand names, with her day-to-day work encompassing clearing, filing, prosecuting, enforcing, and licensing trademarks in the U.S. and internationally. Okay, welcome everybody to today's episode of Party Like a Marketer, the podcast dedicated to cannabis marketing, public relations, and authentic storytelling. Today's guest is Mary Shapiro, the founder and managing director of Evoke Law. Mary, thank you so much for coming on the show.
Thank you for having me.
Yes. Well, let's jump in and get started. Can you tell the audience a little bit about yourself? What is your professional history? And I'd also like to learn more about Evoke Law. How did Evoke get started? And how did you get into cannabis?
Okay, that's a lot of questions. Let's see if I can tackle them one by one. So career history, I've actually had 2 careers. The first was in book publishing and the second was in law. I was always a reader, and I really got, I was fortunate enough to get a job in a college bookstore, which led me into book retail, which led me into book publishing and book distribution. So I had a 20-year career in book publishing. Then I have had what I call my Velcro epiphany, but I'm not going to go into that right now. But long story short, I basically realized I didn't want to do what I was doing for the next 20 years. And I started thinking about what I wanted to do. And I realized that I could leverage my publishing background for copyright law and my marketing background for trademark law. And I said, I'm going to go to law school and become an intellectual property lawyer. And that's what I did. And I started my second career at 45. And nice. I've really been happy. I was happy with the first career, and I'm happy with the second career. Okay, well, what was the other? Okay, how did I get into cannabis? Actually, that's funny too. Well, you didn't really hear the epiphany story, so I can't say it's funny too. But I had a good friend who was in book publishing, and she was kind enough to allow me to stay in her home when I came out here to go to law school for at least the first year.
And where is here?
Here, here is San Francisco. So I went to law school in San Francisco, and I had this publishing friend who was also representing a book publishing company called Quick Trading, which some of you may know is founded by Ed Rosenthal, the guru of ganja, and his wife, Jane Klein. And I got invited to an event at their house and started, there were a lot of cannabis people, obviously. And I, started really getting interested in what was happening, legal, cannabis. It was 1995, so it was before California regulated medical cannabis, of course, well before anybody regulated adult use. So I just started getting interested in seeing what the challenges were, and they were many, as everyone here knows. And that was how I got into cannabis. And later on, when I started my own firm, Ed was kind enough to introduce me to some leading founders of leading dispensaries in the Bay Area. And I was off to the races then. There was another question there. Oh, what does Evoke Law do? So we focus on what is sometimes referred to as soft intellectual property, soft IP. So we focus on trademarks, copyright, domain names, a little bit of trade secrets, but we don't do any patents. But basically, we support our clients in protecting their intellectual property, and that's what we do. And yeah.
Awesome. Thank you for sharing that. So as a marketer myself and business owner, I really did not quite understand intellectual property until I started my own business, and frankly met you when you started defining it to me in more concrete terms versus, abstract terms. So I'm wondering if you can kind of give us the layman's version of what intellectual property is and what it means for founders, marketers, business owners. Like, what's kind of the first step when you talk with your clients about here's what it is and here's why it's important? Can you give us an overview?
Okay. So intellectual property is interesting that you use the word concrete, because intellectual property is intangible. It's an idea, it's a name, it's a written or a video kind of product, and it could be a trade secret, which could be a recipe, for example. In our industry, that's really common. So a patent might be used to protect a extraction methodology. A trademark would be used to protect the brand. Trade secret would be used to protect know-how that people don't know, that isn't public knowledge, that they use in making their products. And copyright is, it's really the written word and video and music and so forth. I think what's really interesting about this is the common thread, though, through all four of those types of intellectual property is that they all relate to something that is original, something that somebody created that's original and proprietary. And so if you have something that you've created and it's proprietary, it's to your advantage to protect it so that other people can't use it. Or if they use it, you have an avenue to go and approach them and challenge them for that unauthorized use. So those are the four forms of intellectual property. And as I said, we focus on the softer forms. And I would say our real core strength is in trademarks. And I think it's because when I was in book publishing, I was the vice president of marketing. And I had two things happen to me that just didn't make sense. And I'm a practical person. I like to give practical business advice, and I like to receive practical business advice. And so one thing that happened is we were creating a new product, and we came up with a name, and we were very pleased with ourselves. And I got to tell you, in retrospect, we shouldn't have been pleased with ourselves. For lack of creativity, for one thing, but also because I didn't even know anything about conducting clearance. And I'll break off in a second, because this is sort of the nub of one of the things that trademark attorneys can do to help a cannabis operator. Conducting clearance means that we look at marks that have been registered, applied for, that are in use, unregistered marks. And we look at domain names and social media handles, because we want to make sure that the operator is not going forward with a name that is going to invite a challenge, meaning that they're going to get a cease and desist letter, like 2 minutes after they launch. Okay, I was exaggerating, but you get the point. So the first thing that happened is I didn't know anything about clearance then. And our corporate lawyer apparently didn't either. And so we ended up getting a cease and desist letter and had to rebrand. The second thing that happened is that we were an international company and we were in 60 different countries. And so different product, different bad name that we came up with. And I'll explain why they were bad in retrospect. I think that what happened was I was trying to figure out how we go about registering our this particular brand name and internationally. And I asked the law firm for advice, and they said, well, you should just register them in all of them. Well, who could afford to do everything? We were in 60 countries. That was just not a good answer. And I in my head, I was saying, well, there have to be like some, maybe you just do the countries that are like your top performing countries, or maybe there's like something else that would help you sort out some law thing that would help you sort out things. And but that wasn't the advice that I got. Shortly thereafter, I went to law school, and then I eventually took trademark law and understood that the way we could have avoided getting a cease and desist letter was by conducting clearance, looking at all those sources. The way that I could have parsed out where to file could have been based on what my instinct told me, which is like how much revenue we were getting from that country. So it was a learning experience, and I'm not sure what question I'm answering now.
Well, you are, because I was going to ask, you've defined it and how it applies to cannabis companies, but I think you just spoke to why we wanted to have you in this show and sort of the inherent gap between marketers' knowledge and the law, because we as marketers are used to creating content, distributing content, thinking of things like that's where we get excited and that's what we like. But where that crosses the line of what is unique, what is yours, what needs to be protected, those are not questions that would come. They wouldn't come to me unless someone told me I needed to think about that. And I think we've seen that several times in cannabis. And I know I've had personal conversations with our members and folks in the industry who have gotten cease and desist, not only from within inside cannabis, but outside. Even I recently had a conversation with a brand who's a very small niche brand, got a cease and desist from a major multinational corporation. And when I had that conversation, I was like, how did they even know about you? How on earth did they make that connection? But obviously those companies have a lot of money, they have a strategy to it, and they're doing what they have to enforce. So you're answering the question and speaking to where marketers kind of knowledge limit does exist often. And I think the need, and I want to have you speak about this a little bit too, to have a strategy behind intellectual property. And it seems like that's what IP lawyers and what your firm does is like advise on what that strategy should be, and how does that work within a company's resources, what their, whatever it is as far as the scope that they need to protect, and to do with it before you create something that has, maybe should not have launched without already done this clearance. So the follow-up question I have for you is, can you explain, I guess, a little bit more about the application of intellectual property in cannabis, and as well as your thoughts on how founders and marketers should be thinking about that strategy, given that a lot of brands might be in one state now, one area, one product line now, but they're likely looking to grow and expand over time as, legalization happens and we all move down this timeline. So can you speak to that kind of strategic aspect and what they should be thinking about before they launch products or services?
So I think it goes back to what I was saying earlier about proprietary intellectual property that someone might have created. So if you have, one of the things I tend to ask my prospective clients is what makes them different from other people that make pre-rolls or other people that make edibles or so on and so forth. And I think sometimes that gives me some insight into what is proprietary and what isn't. But to the extent that it might be an extraction process or it might be a recipe, we talk about, what they might want to do for patent protection or trade secret protection. From the trademark side, though, which is really, I think, what ties mostly into what we're talking about. But let me just take a step back. When I think of a trademark and a brand name, they can be one and the same, but not all brand names are trademarks because they may not reach the level of requirements, legal requirements, meaning that they have to be both distinctive and exclusive. And I can get into that later if you want me to go into the details. But I think what is important is that the brand name is shorthand for a lot of things. A lot of things being, let's say you have a proprietary recipe. Let's say you have a proprietary technology. That is part of what the customer experiences. So it's really important to think about everything that the customer experiences. And I on some level, I think about the intellectual property components on one side of the equation, and I think about all of the consumer experience on the other side. So the consumer experience really relates to where did they get the product? Did they get good service? Did the bud tender tell them like good stuff or weird stuff? What's the price like? Is it relative to the value, or is it something that's high priced that doesn't reflect the value of the product? What else would fall under there? Price, place, promotion. So as far as promotion goes, which is really what the CMA membership is really engaged in, promotion, like, is it accurate? Did the product live up to the language that was used by the marketers, or was it disappointing? Or was my experience better than what I thought it was going to be? But basically what I'm talking at is the consumer experience. And it's a million different details and touch points between the product and the consumer. And I think of all of those as the brand. So, and I realize that most marketers don't have control over customer service or pricing and a million other things, but the brand name is shorthand for the consumer experience. So the brand name is obviously very important. I mean, we all value our own professional relationships. We all value our professional reputations. And so that is part of this. I mean, it's like the brand name is the professional reputation of a product. That's how I kind of see it. So I think as far as founders, they need to consider what they have that's proprietary and see whether they can protect it. And then, from the marketing side, I think that when some of your members who are likely brand name consultants, there's a whole different kettle of fish, so to speak, between what a legal trademark attorney is going to advise a client versus what a branding expert might advise. So for example, one of the things that is a criteria for protection of a brand name as a trademark is that it is distinctive. And with the way that we talk about it in legal language is that it's inherently distinctive. So a mark might be inherently distinctive because it's a totally made up word, like Travelocity. And so it's obviously unique. And it's, associated with the brand. That's a made up fanciful mark. And the next level, or the next type of mark that is important is an arbitrary mark. And I always use the example of volcano because it's not actually a volcano, but it's suggestive of, kind of fire, brimstone, and great smoke, great vapor, I should say. Then the next type of inherently distinctive mark is suggestive. And suggestive means just what it says. It doesn't actually tell you anything about the brand product, but it does tell you something. It does leave you with a feeling. So for example, when I was, I at one point I decided that I need to follow my own advice rather than just telling people what to do. So I was
Been
Mary
there.
L. Shapiro. I was Mary L. Shapiro Law, and I said I got to find something that's inherently distinctive. I can't be telling my clients that they need to do this when I'm kind of just not doing that. So I ended up like really going through that exercise of branding, and ended up with Evoke, which I think is like kind of ironic because it means suggestive, and that's one of the types of marks that are registrable. The second part of this equation, which I mentioned earlier, besides being distinctive, it has to. Oh, before I move off of distinctive, the other type of mark that is really maybe not a mark but can become a mark is when it's merely descriptive. So actually, Bang, BHANG, was merely descriptive because the chocolate this goes back to the beginning of Bang, but the chocolate was cannabis, included cannabis, which is Bang is another name for. So marks that are merely descriptive, that describe a feature, a benefit, a function, a bunch of other things, is difficult, if not impossible, to register. So that's one thing to keep in mind. And I think this is where branding people might have a different view than a legal person does, because a branding person might recommend something that's descriptive because it does a lot of the heavy lifting in the marketing, because the brand itself is actually describing something about the brand. So those are the kind of that's one of the areas where a trademark attorney advice would differ from a branding person's advice.
Thank you for clarifying that. And I also want to add some context that we've spoken with and been in touch with members who at some point want to get their business acquired, or they have. And one part of that due diligence process is understanding how protected is this brand, how much intellectual property is there, and have you worked with an IP lawyer before? So if you're thinking about kind of the lifespan of your business, if your ultimate goal is to sell, it is worth considering paying attention to this earlier in your business, because it will come up later at that point in time.
That's a really good point, Lisa, because the exclusive factor that leads right into the exclusive factor. And it is an unbelievable challenge for cannabis companies right now, because you can't get federal registration for the product itself, but you can get it for a strategy that my firm pioneered back in 2009, is to file for a federal registration for providing information and or education about cannabis. And that is registrable because it's free speech. So, and it doesn't literally touch the plant. So that's one of the things in terms of that needs to be considered. But where I was going was in terms of multi-state operators versus operating in a single state. I'm in California, and in California, we've had legal cannabis since 1996 for medical purposes. There are so many really established brands on the West Coast in general, and Colorado. And the thing is, you could have been using your mark for 10 years, and now you're going into a different state, but someone else could have independently created that mark in that other state, or they could have copied you. So in either case, you're about to run into a landmine when you expand, and that is probably one of the most important considerations that I really like to discuss with clients or prospective clients, to understand what their aspirations are. And then if they want to go international, that adds a whole nother layer on. But basically, when we advise a client, the most important thing that I think that we can help them with is clearance. Having a legal, trained individual opine on the level of risk, and I say the level of risk because there's really nothing that's risk-free anymore, but the level of risk, and unfortunately or unfortunately, cannabis operators tend to be not so risk adverse. And so um, even if we advise them about significant risk, it's possible they might proceed, especially if they've been using the brand for a while. But at least I want them to understand what they're walking into when they're expanding into New York or Minnesota or wherever.
Yeah, what is it? An ounce of prevention is worth a pound of cure. And I mean, we've even seen it too on the regulation side. So, I remember back in 2016, there were some states that specifically wouldn't allow marketing and advertising with green cross or green leaf on it. But if you had already built that into your brand and now it couldn't be used there from a compliance perspective, this is kind of different side of a similar coin of the more you can do your homework in advance and understand from the legal perspective and not just the creative marketing communications perspective, your best path forward, you are going to save yourself from pain down the road. So thank you for describing that and adding that context for sure. Okay, so are you comfortable also speaking to the costs about this? Because I think one thing with startups is they can feel as if they don't want to spend money until they have to, but it can run into that problem that we just discussed where they're trying to save money here, but it ends up costing them later down the road. So for example, I mentioned the member who got the cease and desist from that large corporation. They spent years fighting that against them. What are the costs of action? What are the costs of inaction? Can you speak about that, tangibly and also sort of intangibly, time, money, and anything else to help business owners understand how to prepare for this and how to plan for it?
Okay, well, prices are obviously going to vary amongst trademark attorneys. I know that I know Evoke Law's pricing, and I'll try and interject that. I think what's really kind of important to understand is that there are really kind of two steps. One is conducting clearance to make sure that the mark that you want to use is available with a reasonable risk of reasonable risk. The second part is applying to register it. And so applying to register it is a longer process. But let's start with the clearance, which is can be actually done within 2 weeks and even less if you tried. We always recommend doing preliminary clearance, where we look at the databases, the federal databases, the state databases, and also do internet searches to see if there's anything out there. And then we also look at domain names and social media handles. And the last thing we look at is the licensure databases that are public in various states to make sure that, it's just there's not something obvious on the register that would conflict. And there's really kind of a complex examination of whether a mark would create a likelihood of confusion with another mark. And a likelihood of confusion is the standard for trademark infringement. And it involves considering multiple factors, but initially what you want to look at is the similarity of the mark and the relatedness of the goods. And the more similar the mark and the less related the goods need to be, but they do need to be related. And so that's one thing. But then you can start to look at some of the other factors. I think maybe what Lisa, what you were alluding to before is the non-cannabis company that went after the cannabis company. And it might be because we all think that the cannabis channel of trade is so unique because it's so highly regulated and you can't get cannabis products, outside of a dispensary. Though now you can get, now with the Farm Bill, you can get hemp outside of, I don't know where he would have got him, but you can get hemp products at the gas station, for lack of a, So I think in considering clearance, you really want to know whether your mark is available. That's like the first thing, so that you can avoid getting a cease and desist letter. We start with that preliminary clearance that I just discussed, and then we go into a comprehensive search. And my firm has worked with one of the leading clearance vendors to create a cannabis-centric focused search product. And what that means is that instead of looking at Vogue, they're going to look at High Times, and that's just an example, and you can imagine other ones. But for purposes of clearance, the searches are like highly focused on state trademark registration, since they're available, common law, and this is one of the black holes of cannabis branding, is that a lot of people think they can't register a mark, so they don't attempt to register a mark, and that creates an absence of knowledge because it's not on the database that people look at. So that's like another factor there. But going back to what you were saying about, like, a non-cannabis company coming after a cannabis company, that's really it's really interesting, because I'm betting, but I'm not putting any money on it, that it was probably an edible company.
Close.
You don't want to close.
I don't want to. Yeah.
Yeah. Okay. No problem.
But close.
Yeah. Because the confection industry is on top of, like, they're on top of the cannabis industry. They are just waiting for some giant screw up, and you've seen all. But let's get to the fights that we all know about. Let's talk about the most recent one, which was Skittles with a Z. I personally think that well, first of all, even if it wasn't cannabis, it would have been an infringement. So let's start there. Skittles is a famous mark, I would say, and so famous marks have a broader scope of protection. So you got to really beware of famous marks. But I really resent when people choose names that are attractive to children. I don't think the industry really needs any more give anybody any reasons to pick at us. And that's one that can be avoided. Like I sit here sometimes and think, like, isn't the brand cookies attractive to children? Like, and I know it depends on each state and what they've regulated in terms of being attractive to children. But that's one of my pet peeves is choosing a mark that's attractive to children, which is unique to cannabis because it's just something that's built into the regulations. I don't know if it's in alcohol because I've never heard people talking about it. Okay, yeah, attractive. So that's another thing.
Yes, no, we always say if you have a question about it, it probably is. So err on the side of not. Like, if there's any ambiguity, it could be perceived that way by anyone in enforcement as well.
And here's another, if I could, I'm going to interject with another kind of problem that can come up. Although I kind of got off the track of what we were talking about in terms of how much it costs and what the process is. But let me just say this. So I mentioned that the mark needs to be distinctive. That means it can't be descriptive. One of the things that happens in our industry is that people will adopt a strain name as their brand name. And the problem with that is, if it has the strain in products, all the products, it's merely descriptive. If it doesn't have the strain in the products, it's misdescriptive. So it's kind of talking about two sides of the coin. You just really, you have to be really careful when you're selecting a name. But okay, so back to the process. So the first thing I think that's really important is making sure that the name you're about to adopt is available. The second thing is applying to register. And this is where, I know it costs money and it takes time. But the problem is, if you don't register your mark and you're relying on your what is called common law unregistered rights, you have to prove up where you've been using the mark, because common law rights only protect you in the geographical area that you are selling the product in. So if you're a Bay Area company and you aren't even selling in LA, you don't even necessarily have the whole state. So that's why I think that registration is really important. And I have a little horror story, someone who just didn't listen to me and didn't file for providing information services. and then got challenged many years later by someone who, I'm not sure, it doesn't sound important how they were discovered, but they were discovered. And I can talk a little bit about that, not more generally. But had they followed the advice that they were given about applying federally for federal registration, they would have had evidence of their priority. And priority is a huge deal in trademark law, because not only do the marks have to create a likelihood of confusion, you need to figure out who really has prior rights. And it's not, it can be from the date that you filed, it can be from the date that you first used it. There are just all sorts of idiosyncrasies that get in that. As far as pricing goes, one thing to keep in mind is that not all attorneys have the same pricing. That our pricing includes the fees to the trademark office, the search company, and not just our professional fees. We have a number of packages. The smallest package we have is for around $5,000, and it includes a preliminary scan, a comprehensive search, and a single class application for a single mark. Single class means that the trademark offices all around the world use the same classification system, and there are like 45 different buckets. And so one bucket is going to have providing information about cannabis in it. One bucket is going to have software, and another bucket is going to have beverages in it. And actually that they have beverages are broken up in between non-alcoholic and alcoholic and other kinds of things. But more to the pricing, we also obviously would want to do anything a la carte. For example, if you've been using the mark your client's been using the mark for 10 years, a search may not be as important right now unless they're moving into another state, which is a different creature entirely, but might be just filing the application. So even though we have these packages, which are intended to help by having a preset fee that you can count on and use for estimation purposes and so forth, we also do things a la carte.
Okay, so it sounds like you offer options for business owners, entrepreneurs to control their costs. So there are packages, but you also can do a la carte services. So is that like typical legal fees where it's just an hourly rate and then it's billed against the time it takes to go through these steps? Is that correct?
More or less. I think what's important to recognize is that while many lawyers still bill by the hour, there are some things like searches where we've done them enough time, we have an average amount, and we find that our clients really like to have the certainty of knowing how much it's going to cost. And so we do certain things on a flat fee. There are certain other things that we don't do on a flat fee, like, for example, prosecution of an application, which means that we heard it through the United States Patent and Trademark Office. And that really kind of depends on part whether you listened to our advice and went forward with a mark that has a lot of risk, or whether you chose a mark that is both exclusive and distinctive. So in any case, the process, certain things would be done on an hourly basis, because each situation can be so different. But generally speaking, we like to do the basics at a flat fee so that it's predictable and the client can feel like they're in some modicum of control.
Okay, thank you for clarifying that. You don't know what you don't know. So this is when it's good to get advice from the people who do know what you don't know. And it occurred to me that I think people can hear legal fees. I mean, I was the same way and just say, oh my gosh, that's so much money. But if you're trying to build $1 million brand or a multi-million-dollar brand, like, to spend a little bit upfront to make sure you're climbing up a mountain you can actually summit is really important to protect that. And it can be quite expensive to fight something once you're in it, particularly if you're up against someone, back to that example of that member I talked to who is incredibly resourced, regardless of maybe how right you are or how much you want to fight, you have to be resourced to fight it. So again, that ounce of prevention can be worth the pound of cure.
Yeah, and I think another example of that is I have a dispute going on right now where it's a non-cannabis company against a cannabis company, and I'm pretty convinced that it's the reason why they're fighting this hard is because it's cannabis. Because the amount of hours that have been spent writing legal briefs and uh, you know, everything, it just doesn't make any common sense. And so the only thing I'm left with is that people are the other party is concerned about the fact that my client's brand is used for cannabis.
That makes sense. I could see that being similar to some of the stories I've heard. Yeah, that's how it works in this space. So thank you for telling us about all of that. That makes a lot of sense, and I have learned some things today. So you might have addressed this a little bit, but can you talk about, we've talked about some of the, when we were preparing for this call, some of the common myths in cannabis intellectual property. And I think the biggest one, which you've tackled, is that because it is not federally, it's still federally unlawful at this point, that you can't get any protection. And you did mention you have a strategy for it and there is a way to go about that. But are there any other myths you want to speak to that you feel are common myths within cannabis marketers and cannabis business owners that is important to bring to light as far as this conversation?
I have a couple. One of them that I'm thinking about is a cannabis operator has gone to great lengths to secure a state authorized license in order to run their business. And sometimes it would be easy to conflate those two and think that because the state has authorized you to use the brand, which I'm not really saying that the state did authorize you to use the brand, because the state really authorized you to operate a cannabis business. The other part of that is that it's an easy thing to happen in conflating those two things. Similarly, let's say you got your corporation, your entity registered at the Secretary of State of whatever state you're in. That also has no bearing on whether you can use that name as a trademark. Those databases are in those systems of issuing things are completely unrelated. And last but not least, the same for a domain name. If you get a domain name, it doesn't necessarily mean that you have trademark rights in it. And so there are various things that you need to consider.
I'm actually glad you mentioned it, because I have another horror story from a colleague who is in CBD who was registered with the Secretary of State and another business that was, doing what they did, but they went through several of the listings in the Secretary of State and checked if they had actually cleared those names, and then went after applying for those trademarks. So I've seen it too, where people, this is probably an extreme example, but where that can happen and be vulnerable, whether it's intentional or, kind of by accident, so to speak, just that, that can happen, and partly why it's important. And they also spent years litigating and fighting it, and it had to go to trial, and they ended up winning, but it wasn't, didn't come not at a great cost.
Mm-hmm.
But thank you for clarifying about Secretary of State, and just because you've had approved for the license and kind of your initial pitch and proposal doesn't actually mean the brand is protected.
Yeah. And actually something else that goes along with that is that it's one of the main advantages of filing to register your trademark in the United States is that if you want to, within the first 6 months, you can register internationally and take advantage of your priority date from the filing date. That is only if the application matures to registration. And I do find that a lot of cannabis companies don't have the resources to handle applying internationally because of the costs. But I mention that because it's just one of the factors that goes into the benefits of federal registration. The major benefit is deterrence. I mean, because it's on the United States Patent and Trademark Office database, that's where people go to look. And so that's an important factor as well.
That makes sense. Okay. Well, I am curious if you have, we've covered a lot, but do you have any like parting advice for cannabis marketers or business art owners, regarding intellectual property? Like anything we didn't cover that you want them to know or to talk about before we wrap up?
Well, one thing that comes to mind is that there are rules for proper use of a trademark, and they don't intuitively make sense unless you really know why. But for example, you're not supposed to use a trademark as a noun. It's supposed to be an adjective that modifies a noun. Now I know your eyes are rolling and I completely understand.
I'm thinking,
I,
I'm like
uh,
noun. Yeah.
yeah, so it's like, so the noun would be the thing itself, like the generic term for the thing itself. Like I'll use volcano vaporizer.
Okay.
But if you use volcano as a noun, that's one. It's like there are like 6 or 7 rules for proper use. One is to distinguish it from surrounding text. One is to use the proper notice symbol, whether that's an SM, a TM, or an R in a circle. And another one is to use it as an adjective, because it's basically a trademark is a source identifier, not necessarily an identification of the product. And so I think this will resonate just about everybody here. When Kleenex kind of lost control of their brand, is because people were using Kleenex interchangeably with tissues. And it's really Kleenex tissues, not Kleenex. And so that required them to jump through a lot of hoops. And that worries me when people come up with potty marks too, what I call potty marks, slang for pot, because the trademark office is hip to this and they look at the Urban Dictionary. That's one thing.
That's
But the other,
hilarious.
so it just makes it like, more vulnerable because it's descriptive. And then I could also comment on crowded field, which is kind of interesting about this where you're going towards, and that is sometimes a term is used so commonly in an industry, like green in our industry. That's a good example. The green component of a mark is not protectable. It's just everybody's using it. And sometimes you might think like the advice that we give clients is that like no one owner can really successfully enforce, this term that's in the crowded field. And so that kind can lead an operator to thinking, well, okay, I can use it because nobody can stop me from using it. So, and that is one of the objectives. It's like you just don't want somebody to stop you from using it. That's a lower bar than distinctive and exclusive. So crowded field, but the problem is, the other problems are, besides it having difficulty in protecting it, is that you're going to have SEO issues. You're just going to have a whole series of issues that pile on from that. I mean, I always use this example. It's not a Cannabis one, but I always say, I don't know the difference between Petco, Pet Food Express, PetSmart. I only know them by location. And I don't think that's really good branding in terms of like, identifying who you want to purchase your services from. Unless you're doing it by location, which I go to the Pet Food Express, which is the closest to me. Anyway, I'm off on another tangent.
No, that makes sense. That adds context. So is it probably the same with Mary or Bud or Flower, as far as what did you call it? Crowded fields? Like these are just common terms for an industry, or would pet be the equivalent in the pet supply space?
That's what I think.
Okay,
That's what
that
I think.
makes
And I
sense.
think just about any potty term, it just, and that's, I always joke about this, and I'm not making fun of anybody really. Maybe, I don't know. But if you sit around and you're trying to come up with a name for your company and it's 2 o'clock in the morning and you just landed on something, you're really excited. But you just may not understand that it's neither distinctive or exclusive. And I just, that's where I come in.
That's helpful. And I mean, you're in San Francisco, so you're right. I think the tech industry does this so well. Like every app and new service or software out there is completely made up names that are now I'm able to understand and articulate that must be distinctive. And, they went through the process of going through what you've described today, as far as checking what they need to do for their intellectual property up front so they can build a brand. And thinking about Kleenex, Uber is an example. That's kind of a marketer's dream, right? Like, I'm calling a rideshare service and I say I'm calling an Uber, whether or not I'm actually using Lyft as an app. Because that just, marketers have made it now. And that is the marketer's dream, is to kind of infiltrate the lexicon and the communication so much, but that doesn't mean it's not without, there's a legal side to that too. So
you got it. That's precisely it. That's where some of the legal considerations are different from a branding person's point of reference.
yes. And well-funded industries clearly spend a lot of money to make sure they get it right, because they're building big businesses and big brands. So they're protecting themselves. Okay, Mary, anything else you want to mention or we haven't covered today?
Well, I think what I'd like to mention is how you can get in touch with Evoke Law. Evoke Law is at evoke.law, not .com. That was another thing. I was really into the new top level domains, and I really want, and I think what's interesting about it is, like, if you look for evoke.com, I don't even remember because it's been so long. I don't know what's there. But I went with evoke.law because I just thought it brought the law into it, but it's made it shorter to remember. But anyhow, evoke.law. You can reach us by email at IP, intellectual property, IP law at evoke.law. There's a place on our website. There's a place on our website for signing up for information, newsletters, and so forth. And I'd be happy to chat with you, any of you marketers or operators, and just share stories and parse out some nuances.
And you also do complimentary 30-minute consultations, correct? Or appointments where you'll meet with business owners and, kind of talk about what we just talked about today.
That's right. We do offer a 30-minute free consult. It's not really a consult because we can't advise people on the law until we have attorney-client relationship. But what we do is we have this session, and I think it's important for you to get to know us and figure out whether you want to work with us, and it's important for us to know whether we want to work with you. I'm speaking of operators in particular, but yeah, we do offer and you can sign up on the website. You can.
Awesome. Well, thank you, Mary. I so appreciate you taking the time to have this conversation with us. And marketers, we will leave links to Mary's website and her email address in the show notes, so you can find that where you listen. And I appreciate it.
Thank you so much for having me. As a former marketer, I really love the intersection between legal and creative. So I'm totally on board with everything that CMA does.
Thank you. Thank you so much for listening to today's episode. And we encourage you to check out our membership if you're not already a part of the community. We've got an end of year special running for our annual business members. If you have any questions, you can reach out to us at membership@marketingcannabis.org, and we'll tell you about all of our benefits as well as the promotions we've got going on and how you can get plugged into the cannabis community and or get interviewed on this show. Thank you all, and see you next episode.